is this agency even allowed to regulate in this space at all? We're the Armed Attorneys. Today we're talking about some major implications from the last term of the Supreme Court, big cases, stuff that might have even flown under the radar, and how, when we had our Declaration of Independence, how some of those grievances might still be alive today. But before we begin, show your support for the Second Amendment by hitting that like button. And we got to give a shout out to today's sponsor, Legal Heat. They've trained hundreds of thousands of folks in concealed carry classes all over the United States. If that's something that you're interested in, join a whole bunch of folks who have done it and had great success. Check them out over at legalheat.com. We got a link in the description below, promo code Armed Attorneys. Now, to start things off, Edwin, the first big case, there's three big cases that I want to talk about. But the first one, and I will say the primary one for this video, is I think kind of flew under the radar. Maybe not a whole heck of a lot of people were talking about it because we're all so focused on New York State Rifle and Pistol Association v. Bruin. And that's the state of West Virginia versus the Environmental Protection Agency and the implications that this has on gun rights. So give us an overview of that case.
Yeah, and so the reason that gun people may have not paid close attention to this is because it was billed by the media as an environmental case. That basically the media was saying that now the administration's hands are tied because they cannot make rules regarding climate change, environmental rules. But the case obviously has much broader implications than that because it addresses the power of the administrative state. And, for all of us gun folks, of course, the dangerous administrative agency is the ATF. They're the ones that make the rules. They're the ones that enforce the laws.
They're the ones that hate dogs.
They're the ones that hate dogs. And so this case is going to be very impactful for them. And it really is quite a blow for freedom because, traditionally here in America, we were founded on the principle that our elected representatives make the laws. Well, over the course of the last 50, 60, 70 years or so, Congress has been delegating that authority to administrative agencies. They have grown beyond the scope of their intended use. They not only enforce the law now, they actually make the law in many instances. And this case said that they cannot do that anymore.
Yeah, and this came out of the EPA trying to push some green energy policies, some carbon emission standards down the throat of West Virginia. And West Virginia said, hey, this is not within the Congress has not given you the authority to regulate in this area. And therefore, we don't think that you can legitimately impose these type of regulations on top of us. And what, this worked its way up to the United States Supreme Court, and they agreed with the state of West Virginia that the EPA has stepped out of line. And we got a reaffirmation and a really clear expression of a doctrine called the Major Question Doctrine. Now, what is the Major Question Doctrine, Edwin?
Well, the Major Question Doctrine basically says that if the question, basically the area to be regulated, involves vast political or economic consequences, then that either has to be done by Congress expressly themselves, or they have to expressly delegate that particular process to the administrative agency. You can't just say, hey, administrative agency, go make up these rules. Their boundaries have to be clearly set forth. And like I said, the governing principle is it a question involving vast political and economic consequences? And certainly I believe that the regulation of the Second Amendment is one of those questions.
Yeah, and another case that's going to come up, we'll see this hopefully next term, is the Aposhin v. Garland case, and this has to do with Chevron deference. Now, I'm sure you've heard about this, and this is the standard where administrative agencies are allowed to interpret the rules that Congress lays out. Maybe if there's an ambiguous statute, they can, they have some deference into, how they interpret it and apply the rule. Now, this is bigger than Chevron deference. This is, is this agency even allowed to regulate in this space at all? We're all very excited about the Aposhin v. Garland case, but this has even wider ranging implications of, has the Congress even delegated this authority to the ATF? And if you go poking around the United States Code, there's a lot of places where they have not been allowed to regulate.
Well, and this is going to affect things like, of course, the bump stock regulation, where the ATF basically unilaterally declared that a bump stock is now a machine gun. They have declared that various parts of a firearm now constitute a completed firearm. And of course, they are currently interpreting as to whether or not a stabilizing brace constitutes a stock, thereby making a firearm able to be fired from the shoulder. And so if the ATF is determined not to have the authority to reinterpret these definitions, then all those regulations go away.
But this has wide-reaching implications on the administrative state. We see a lot of history in the American tradition about, we want to know the rules that we're governed by. That's something that comes out of, we see this out of cases all the time saying, we have to understand the rules that apply to us so that we can make judgments about how to live our life. But I think you found a really good quote, Edwin, that you wanted to share.
Well, we want to know who makes those rules. And it's important for folks to remember that it is the administrative state that was one of the driving forces behind our desire to have independence from Great Britain. The Declaration of Independence, we're all familiar with it. Basically, it's a list of grievances. It's a list of crimes that the king has created against the colonists. One of the major crimes that the king was accused of committing was creating a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. And I think if you look at the administrative state today, that's exactly what the administrative state does. It's a horde of new offices and swarms of officers to harass the people and eat out their substance. So anytime the courts will seek to limit that, that's a victory for freedom.
We see West Virginia versus the EPA. We see New York State Rifle and Pistol Association v. Bruin and a Potion v. Garland, which we will see next Supreme Court term, which begins October the 3rd, 2022. We see all these three cases moving in the same direction, and I do think that they will have the same effect as to rein in the administrative state. We hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. Also, support those who support the show. Check out our friends over at Legal Heat and leave a question in the comment section below. And until next time, we're the Armed Attorneys.